Welcome back to Organized, the business law breakdown. And in this new season, we're going to be mastering limited liability corporations, or LLCs. LLCs are a flexible new entity type. And in this episode 1, we're going to describe what is the LLC and talk about the journey we'll take over a 10-episode course this season. So many modern businesses, ranging from single-member startups to large-scale real estate ventures, are choosing the LLC form, and we'll discover why. LLCs blend liability shields of a corporation with the fluidity of a partnership, and thanks to some tax law that makes them very appealing, we're going to see how they give almost endless contractual freedom. Now, before we even jump in, you might think, everyone should choose a form which provides the most freedom. But that's actually not always the case. Think about going into a store and deciding whether you're going to buy a pre-made suit jacket or a dress, or a bolt of cloth and a pattern. While you might get something that fits better by buying the cloth, it's a lot more work to custom tailor it. And over years, many businesses fit well into the off-the-rack solutions that corporations, partnerships, and other forms offer. So LLCs aren't always the right answer just because they're flexible. That said, they have huge potential, and we're going to talk about them this season. Picture two friends launching an e-commerce side hustle. They want a few features. They want personal liability protection. Neither wants to be responsible for the debts, and for that matter, the torts of this business. But they hate corporate rigidities. If you form a corporation, you have to elect a board of directors. You have to issue shares of stock. You have to have annual meetings. Corporations also are taxed as entities, and they may prefer pass-through taxation to avoid the double tax of a typical C corporation setup. You could file as an S corporation, but there are extra details there as well. And so we enter the LLC. The limited liability company is a legal innovation that's transformed American business law over the past few decades. Historically, if you wanted limited liability, your best option was a corporate form. But these are thick with formalities. And as I mentioned, double taxation, unless you qualify as an S corporation, which has some limitations. Partnerships are simpler structures. You don't even need to file to form one. But partners are personally liable for business debts, and that includes the debts that others cause. In the 1980s and 1990s, states started authorizing limited liability companies through a new statute, mainly built around the Uniform Limited Liability Company Act, produced by the American Law Institute. And as a result, many states adopted similar LLC structures. However, they didn't take off just yet because, as we'll see on our journey, we needed some tax rulings that really governed and gave some confirmation around how these be taxed. But this is an example of a legal innovation, a new legal technology where states, especially states outside of Delaware that were competing to be havens and homes for businesses, created new laws in order to cater to a different type of business. Just by the way, we'll talk about this in a future season, but one thing I'm really excited about is how many states are doing this again with decentralized autonomous organizations, or DAOs. And it's one area that I specialize in researching. I think we're going to see another revolution as states allow DAOs to form, just like limited liability companies provided a new way for businesses to form and became very popular. Anyway, sometimes I'll talk about the Uniform Limited Liability Company Act, or ULLCA, and that refers to the limited liability law in most states as it's been adopted. Section 108 of the ULLCA refers to an LLC as a hybrid between a partnership and a corporation, and it's designed to modernize small business structures. And by the way, the reason that I teach LLCs after I teach partnerships on the one hand and corporations on the other is I think the easiest way to understand this hybrid is to understand these component parts of which it were made. It has features of a corporation, features of a partnership. So if you haven't actually listened to the seasons on partnership and corporation, you might pause here and go back to those, because I think it's fundamental to understand what are those polar extremes And that way we understand how a limited liability company mixes and matches elements of both. Let's talk a little bit of statutory history. Wyoming, which also has innovated with one of the first Dow statutes, passed the first LLC statute back in 1977. And it fueled a wave of imitators. Once IRS ruled, in IRS ruling 8876, that LLCs can enjoy partnership-style pass-through taxation simply by checking a box and electing partnership taxation. That means that it doesn't matter whether an LLC is actually designed to be governed like a partnership. You can govern an LLC like a corporation. You could have a board of managers that functions like a board of directors. But so long as you check the box, you can be taxed like a partnership. No dreaded corporate double tax. This is a huge innovation, a huge development that allowed this innovation to really take off. And today, every state has an LLC statute. Most are modeled on that Uniform Limited Liability Company Act. I'll also mention that some have innovations beyond that, like some states allow series LLCs, and there are other flavors we can get into when we talk about advanced topics. But again, most states have some version of the Uniform Act. And that includes limited liability. Under ULLCA Section 102.8, members are shielded from personal responsibility for the LLC's debts, similar to shareholders in a corporation. So if that e-commerce venture racks up supplier debts, members' personal assets remain off limits, unless, of course, there's room for piercing the limited liability company veil. In a future season, we'll talk about piercing the corporate veil. The same concepts apply to piercing the limited liability company veil. The reason I talk about that later is because those piercing concepts relate to all the entity forms that we'll discuss. Piercing is the limit to limited liability. Although you enjoy limited liability so long as you comply with the law does allow for shareholders' assets to be targetable in litigation under certain conditions. So just kind of put it in the back of your mind, there's a concept called veil piercing, and it applies to LLCs and corporations too. But for the most part, so long as you observe corporate formalities, the shareholders, or in this case, the unit holders, enjoy limited liability. The second is pass-through taxation. Corporations are generally taxed at the corporate level. There's a concept called S corporation, which we talked about in our season on corporations. But in general, corporations pay corporate tax, and then they make distributions or dividends to shareholders, which are also taxed. This is known as double taxation. But with an LLC, you can treat it like a partnership so that the entity is disregarded from an IRS perspective. And this allows what we call flow-through taxation. It literally flows through to the partners who report the income or losses on their personal returns. They get a K-1. This check-the-box approach is critical based on IRS ruling 8876. And corporations, again, they don't check the boxes easily, as corporation requirements are stricter. It's still an option. I will mention here briefly, talk about tax later too, that flow-through taxation is not always a good thing, because when you disregard the entity, the profits are attributed to the members, whether or not there's an actual distribution. So one challenge that comes up with pass-through taxation is phantom income. You might have to report income to the IRS, even though you don't get cash to pay it. We'll deal with that one later as well. Let's go to the third element of LLCs, which is crucial, contractual flexibility. The LLCs have an operating agreement, which is a contract between its members and its managers that can shape the business almost any way the members want, except they can't be run by algorithm. And that's where the Dow innovation comes in. Dow LLCs are even more flexible, where you can actually govern an LLC with an algorithm or with some type of governance structure based on tokens and blockchain. Again, a future topic, pretty exciting, but LLCs, the conventional ones, back in 1977, no one was thinking about blockchain. And so you did need human beings to govern the company. They could be members or managers. And beyond that, you can allocate profits, you can allocate losses, you can allocate governance in all sorts of super flexible ways. And so LLCs need some kind of operating agreement that defines all these things. And ULLCA Section 104 emphasizes that the state has default rules that only apply if the members don't override them. Corporation law generally is more formal and more constrained by corporate code. So if those off-the-rack solutions are hard to tailor to meet your needs, an LLC can be a better fit. In addition to choosing corporate form, of course, business creators can choose the state of incorporation. And thanks to the internal affairs doctrine, the state of incorporation will govern the internal affairs of the company. So if you form an LLC in Delaware, you can do this even if you live in Texas. You can form an LLC in Delaware no matter where you live, in fact. You'll be governed by the Delaware Limited Liability Company Act. And you'll be subject to the Delaware courts regarding your internal affairs. And this can be an advantage because the Delaware courts have extensive case law paralleling its corporate jurisprudence. So if you crave robust legal precedent and you want to avoid the kind of uncertainty that can come up in a smaller jurisdiction that just has less case law, Delaware can be a prime pick even if you don't choose a corporation. It's worth noting that Delaware has its own Limited Liability Company Act that doesn't fully track the Uniform Act, and other states might have other features you prefer, like as I mentioned, you could have series LLCs, which are useful especially for real estate ventures, and there are some states that have more advanced forms, and I alluded to them earlier, like in Wyoming, you can have a DAO govern your LLC. They always seem to be on the cutting edge of corporate innovation. So there are reasons not to choose Delaware, but there are reasons to choose it for legal certainty. And I also just want to mention that the IRS ruling 8876 really supercharged the LLC movement because, just as a historical anecdote, prior to that, you would be taxed like a corporation if you had corporate characteristics, like corporate management. But again, after this ruling, you just check the box, and then you can run it however you want, and you'll be taxed in a consistent way. Today, LLCs outnumber newly formed corporations in basically every state, underscoring how profound legal certainty is when it comes to forming corporate forms. Now that I've introduced you to the core appeal of LLCs, which include a flexible structure, limited liability, and potential tax perks, I hope I've motivated you to stay with me for the next 9 episodes of this particular season. In episode 2, we'll dive into formation, covering how to file the certificate of incorporation, or I should say the certificate of organization, under ULLCA Section 201. And we'll talk about the crucial role of the operating agreement. There are pitfalls if you rely on oral agreements or implied terms. So we want a well-defined operating agreement. Talk about that in episode 2. In episode 3, I'll call Management Wars. We'll discuss member-managed versus manager-managed LLCs. We'll talk about the default rules and how to navigate possible management conflicts. In episode 4, I'll take a deeper look at that operating agreement's design, going beyond formation to some of the more technical aspects of voting thresholds, allocations, and what are manifestly unreasonable terms to avoid accidental ambiguities and unenforceability in an LLC operating agreement. In episode 5, we will dissect ULLCA Section 409 to discuss to what extent members can modify fiduciary duties. So one thing that's super interesting about LLCs is they're, as I said, very flexible. They're even flexible in terms of waiver of fiduciary duties. We learned in our chapter on corporations that managers owe a duty of care and a duty of loyalty. The duty of loyalty can't be waived in a corporation. The duty of loyalty kind of can be in an LLC. Kind of interesting. Stick with me on episode 5 to talk about fiduciary duties in LLCs. Episode 6 preludes veil piercing. Like I mentioned, veil piercing is a larger topic on its own, but we'll talk about it here as well. When the LLC shield fails, when we have a single member that is potentially commingling assets, we might have issues that don't allow that person limited liability. In episode 7, we'll talk about the end of the LLC, not of the form itself, but of the organization in particular. It can end through disassociation, dissolution, and deadlock. And if you've been following me so far, you'll notice I'm using terminology from partnership law. So those concepts apply here as well. Hopefully you listen to that season because we'll be reviewing that here. There could be voluntary or judicial dissolution under ULLCA Section 701, and we'll talk about some memorable cases. But again, this really draws from partnership law, so hopefully we listen to that season already. In episode 8, we'll talk about mergers, conversions, and entity transformations because LLCs can become corporations, and in fact, corporations can become LLCs, although there are tax consequences when you shift, and we can also merge them together. Sometimes startups will start as an LLC and become a Delaware corporation when seeking venture finance, and this type of conversion is an interesting and important transaction in the startup lifecycle. In episode 9, we're going to move to advanced frontiers. I've been preluding some of them. Here I'll talk about series LLCs, DAO LLCs, professional LLCs, and how states are experimenting with decentralized, distributed governance. I know it sounds fancy, but it's actually here. Blockchain governance is already happening in corporations in America today. And finally, in episode 10, I'll provide some comparative insights that will kind of capstone this whole module on our season on partnerships, corporations and LLCs. I'll focus on entity choice, and now that you understand all of these things, we can make strategic decisions given a business scenario. In short, by the end of this season, you'll grasp why LLCs have become a go-to choice for countless entrepreneurs and established businesses alike, and perhaps you'll also know when not to choose them. So I'll see you in the next one, and for now, I'm Professor Seth C. Oranburg, and this is Organized, the Business Law Breakdown. Hello, and welcome back to Mastering LLCs. In our season on LLCs on Organized, the Business Law Breakdown, I'm Professor Seth C. Oranburg, and as a reminder, in our last episode, we distinguished member-managed and manager-managed LLCs, and I'm glad I don't have to say that 3 times fast anymore. Today, in episode 4, we'll dive deeper into the operating agreement, the all-important contract that shapes LLC governance. We'll look at permissible versus prohibited terms under the Uniform Limited Liability Company Act. We'll look at voting rights, profit allocations, and transfer restrictions. We'll highlight what manifestly unreasonable limitations of liability means and how it can invalidate extreme contractual modifications. So we've got a lot to cover. Let's just dive right in. By now, you've heard me describe the operating agreement as the LLC's constitutional charter. And you've had me remind you over and over that it's very flexible, and so you have to read it because it can customize virtually every facet of governance. Who votes on major decisions? How profits are distributed? How new members join? Or what fiduciary duties look like. If you do nothing but file the certificate of formation, or the articles of formation, the Uniform Limited Liability Company Act, or the state's default rules, which are typically based on the Uniform Act, fill the gap. But in reality, most entrepreneurs prefer to define these rules for themselves, and any complicated business should. The upshot is that you have contractual freedom, and with freedom comes responsibility. In a corporation, the charter and bylaws are heavily constrained by mandatory statutes, especially around shareholder rights and board structures. An LLC's operating agreement can be far more flexible, letting members set creative rules for capital contributions, voting thresholds, or special allocations. But that freedom isn't absolute. The Uniform Limited Liability Company Act forbids certain terms, especially those that unreasonably slash fiduciary duties to zero or externalize too many risks by hurting creditor protections. So let's turn to the statutory language. And again, I'll be referring to the Uniform Act, which has been adopted in one way or another in most states. Section 105 addresses what an operating agreement can and cannot alter. For example, you can't override the need to file a certificate of incorporation, and you can't refuse to designate a registered agent. The state needs to have the ability to sue the LLC, and you need to have public notice of the LLC's existence. You can't change that. You can't eliminate the implied covenant of good faith and fair dealing. You can redefine how members interpret good faith, but you can't say we don't owe any good faith or fair dealing obligation to each other. That's an inherent feature of contractual arrangements, and an operating agreement is a type of contract. You can narrow or clarify what the duty of loyalty or care means. The Uniform Limited Liability Company Act forbids removing them altogether, although some states have taken more liberal approaches. You can remove duties of loyalty or care for managers or members so long as it's not manifestly unreasonable. Obviously, I can't tell you exactly what that says because the language is designed to be flexible and not subject to inherent definition, but we'll see some examples and get some ideas. And obviously, you can't contravene state or federal law. An operating agreement can't legalize something the statute declares illegal or adopt governance contrary to public policy. Just as a reminder, all statutes in America have to be constitutional. An unconstitutional statute fails. And below that, all private contracts and all corporate arrangements have to comply with the statute. So we can't do something that violates the statute. And we can't adopt governance contrary to public policy in states that have contravened it in their enabling statutes. As a comparison, in corporations, certain features like electing directors or holding elections are relatively locked in. In an LLC, you're freer to choose, but you have to respect mandatory statutory floors. Now, how about that manifestly unreasonable standard? Uniform Limited Liability Company Act Section 105E provides that a operating agreement can modify and limit fiduciary duties so long as it's not manifestly unreasonable. What does that mean? It means we are in the fact-specific world of case-by-case analysis. Courts typically scrutinize agreements in the context of the LLC's activities, membership, sophistication, and potential harm. They ask, does this provision go so far as to create a fundamental unfairness? For example, a clause eliminating all recourse against any manager for intentional fraud or willful misconduct probably crosses the line. Another line crossing might occur if we force members to waive rights to ever see company financials. So don't try to disclaim every aspect of loyalty or care. Think about safe harboring certain transactions or requiring disclosures for self-dealing and having some process that borrows from corporate law and the cleansing of interested transactions in a manner that might simplify them but offers some process because we don't want to appear manifestly unreasonable. The concept balances contractual freedom with a guardrail to prevent extreme or abusive provisions. You can't just let the manager loot the LLC without consequence and expect that to be fine. Beyond fiduciary duties, the operating agreement often addresses day-to-day governance and economic rights, like voting rights. By default, many states tie voting to ownership percentage. So as a default, the number of dollars that you have invested might result in the ownership you have in the company and the number of votes that you have. In other states, it's one person, one vote by default. But again, the operating agreement should control this. We should specify. We can do all sorts of interesting things. We can create special classes of members with different weights of vote. Just like in a corporate stock system, we could have super voting shares or non-voting shares or preferred shares. For big decisions like amending the operating agreement or dissolving the LLC, the operating agreement could require a supermajority or a unanimous vote. Again, the LLC agreement defines the operation of the company. Very flexible. In terms of profit and loss, the default rule is to be proportional to contributions or interest. But again, operating agreements get creative. Some members might get a guaranteed return. Some might get a preferred return upon the sale of the business, similar to a liquidation multiple in venture finance deals. Or we can set waterfall distributions that provide full return of investment to certain investors before any get the residual. We could structure it like a venture financed company. In fact, again, we could do almost anything. Now, when I say we, I really mean skilled attorneys that understand venture finance. We don't want to be monkeying with this stuff too much if we don't know what we're doing. And there has to be a good reason for adopting one of these structures. Here is a word of caution. If you're listening to this after having downloaded your operating agreement from LegalZoom or based on a PDF you found on the internet, it might have allocations that make no sense for your business. And this corporate finance stuff gets a little technical. I teach an entire semester-long course on it, so I can't cover it all right here. I'll just end by saying that one major issue that comes up is that if we allocate profits, that means that those profits show up on members' tax returns, whether or not we have distributions. So if there's only one thing you're going to look at, you want to make sure that if there's a profit allocation, there is also some type of cash distribution, because otherwise we could have bizarre situations where the IRS can say a member of your LLC owes a ton of taxes and has no cash to pay. That's a major problem, although again, it's not the only financial problem that comes up. Let's talk about transfer restrictions. In a partnership in general, you can't transfer your voting interest. You might be able to assign your financial interests, but in general, a partnership is based on trusting your partners. And in a membership of an LLC, we might have the same situation where we could have transfer restrictions against selling to strangers. And that's a more partnership-like LLC. We could also have a right of first refusal where the operating agreement says that if you want to sell your units or your interest to somebody else, the other members get to buy it at that price first. Or we might have a unanimous consent provision to admit new members. We can do all sorts of things. And before you think this is just esoteric, picture a few common scenarios. There are 3 members. One of them dies. What happens to the interests? Does the operating agreement account for that? Can the 3 people that inherit the estate all become members now? Well, depending on the balance of power in the governance of that organization, if the idea was 1 member, 1 vote, we just went from 2 people being able to overrule a third to the children of the decedent being able to overrule the new members. All kinds of situations like this come up. And so, although LLCs are flexible, you might not want to make one if you don't know what you're doing. Or consult a good lawyer and talk about how membership interests could be transferred upon divorce, bankruptcy, death, and other life and death events. In a corporation, transferring shares is so much simpler. Stock is freely transferable, and unless there's a shareholder agreement restricting it, we basically have 1 share, 1 vote, and it can be inherited, etc., etc. LLCs can do all sorts of things, and they can have more of a club or partnership vibe. This lower liquidity for members can create problems if you didn't intend that, or it can be desirable if the idea is to keep tight control. Lawyers and members often push the boundaries of contractual freedom. They may get too clever by half. If an operating agreement is 80 pages long with labyrinthine definitions, ordinary members might not understand the rules. This itself can fuel later litigation. And any agreement that's that long may not be very well drafted. I generally find that complicated agreements are usually still around the 30 to 50 page length. But again, if you have a complicated LLC, something more than a single member LLC, you really want an attorney who specializes in this subfield of corporate law to do it, because even in this season, I can't cover every single operating agreement term as well as everything else. So you'll just have to take my word for it. It's very important to think about these things carefully because we have so much flexibility. And if you're not comfortable with that, choose a default form like a corporation. And you can still get flow through taxation if you can get an S election. If the agreement is drafted badly, if we have ambiguity, courts could read it in one of many ways. They may prefer the plain reading. They may revert to statutory defaults. They may add a term or say that that term doesn't apply at all because it doesn't make sense. And a poorly drafted agreement can have contradictory sections about distributions or management authority. One major risk happens from boilerplate recycling. Lower quality attorneys and many people that do that themselves will copy paste from forms. And a kind of mid-range approach is to get a bunch of forms and cobble them together and hope that it makes sense. This is not a terrible first step, but the result can be forms that omit specific terms the LLC needs, or duplication of terms that end up making it not make sense. So again, the operating agreement requires careful review by a professional attorney. And it should be reviewed periodically because major business changes occur. If there were new members, if there were expansions, if there was a change in how business is done, if the structure shifted more toward a management style. These are all reasons to update the operating agreement. So this deep dive really just scratched the surface. I guess it was clickbait to call it a deep dive because really to go deep on this one, we would spend the next semester together learning about all the ins and outs. But I hope what you learned is how important the operating agreement is and how a well-structured operating agreement not only keeps members aligned, but helps avoid some of the legal liabilities that result from having default rules that weren't intended or ambiguities which are hard to resolve or other drafting errors. So we've covered permissible and prohibited clauses, the manifestly unreasonable standard, and the essential topics of voting, profit allocations, and transfer restrictions. And we remember that the magic of LLCs, as well as their downfall, lies in their contractual flexibility. Next time, in episode 5, we'll examine fiduciary duties in detail. We'll expand how far you can contract away loyalty and care, and we'll take a look at some real cases. Until then, I'm Professor Seth C. Oranburg, and you've been listening to Organize, the Business Law Breakdown. I'll see you next time.